The International Criminal Court is now in session.
Good afternoon, everybody, or depending on where you're at, the time zone, a good day or a good morning. And the International Criminal Court is here to hear the prosecutor against Lord Blaze before the pre-trial chamber, today comprised of Judge Axelson, Judge Seoane, and Nicolai Bülte. And before we start, I think you're familiar with the rules. You have 25 minutes to plead your case each, plus 5 minutes for rebuttal. Before we start, would counsel for the prosecution kindly introduce themselves?
Good afternoon, good morning. I am Isabel Marcondes, and I represent the Office of the Prosecution. And I shall argue during the coming 25 minutes and consider all the submissions before the court alone.
Thank you, counsel. And would counsel for the defense kindly introduce themselves?
Good afternoon, Mr. President, Your Honors, may it please the court. My name is Martina Calcaterra, and I will be representing today the counsel of the defense. I will speak for around 15 minutes, while my colleague, Mr. Bastianini, will speak for the remaining 10 minutes.
Thank you, counsel. And then the prosecution has the floor.
So if I may proceed. Good afternoon, Mr. President, Your Honors, the representatives of the defense and distinguished audience. May it please the court. The case ahead concerns the enslavement of at least 30,000 earth hours, and the crime of enslavement is a serious violation of a well-established and widely recognized standards of international law. It removes the victim's freedom, treats them as mere objects, leaving them vulnerable to inhumane treatment. This case is therefore of significant importance to be tried by this court, as it sets down that no one should be above the law or beyond the reach of international justice. And we make 4 submissions. First, that the case against Mr. Blaze falls within the jurisdiction of this court, as the enslavement meets the requirement of a crime against humanity. Second, that the case is admissible as no trial in the matter has taken course. Third, that the case serves the interests of justice. And lastly, that there are reasonable grounds to believe that Mr. Blaze is individually criminally liable. Your Honors, on the first issue of jurisdiction, this court has jurisdiction, as there are reasonable grounds to believe that the crime against humanity of enslavement has come to pass, pursuant to Article 5b of the Rome Statute. And on a first scope, with regards to the specific elements of the crime, we say that the act of enslavement is clear, as the element of forced labor, a usage of right of ownership, is present. In the ICC Nataganda and Katanga case, respectively in paragraphs 1952 and 1975, this court noted that the right of ownership and the powers attaching to it may take many forms and are not exhaustive. In determining whether the perpetrators exercise such a power, this court must take into account various factors. The most relevant for the present case is the existence of forced labor. According to Article 1, Paragraph 1 of the Forced Labor Convention, forced or compulsory labor has 2 main requirements. It must be carried out without consent and under the menace of a penalty. In relation to the first requirement of consent, the Inter-American Court of Human Rights in the Ituango case has noted that all work in the course of unlawful detention is to be regarded as forced labor, which was confirmed by the ICTI's Chronelaiaki case in its appeal judgment, paragraph 200. In the concrete case, Your Honors, thousands of earth bowers were unlawfully detained without due process or individual guarantees, such as information on the legal basis of their detention or the length of their sentence, according to paragraphs 5 and 13 of the case facts. This violates human rights standards on the prohibition of arbitrary arrest and detention. Furthermore, regarding the requirement of a menace of penalty, according to the Forced Labor Conference reports, this covenant entails any penalty or punishment which implicates in the loss of rights. In the concrete case, this requirement is also present, as the detainees refused or were too weak to work for 12 hours a day, every day of the week, with only 30 minutes lunch break in inhumane conditions, were forced to stand out outside in the snow all day, in front of a picture of Mr. Blaze, without any food or water, while the BNS officers watched, according to paragraph 12 and 13. Hence, The prosecution submits that the detained Earthbauers were indeed submitted to forced labor, indicating that the right of ownership and therefore the existence of the crime of enslavement. On a second scope, regarding the contextual elements, the prosecution submits that they are also established, and we split in two of arguments. First, that the attack was sufficiently widespread and systematic, and second, that this attack was pursuant to a state policy. On the first submission of widespreadness, according to the ICC's and ICTI's case law, the notion of widespread refers to the large-scale nature of the attack and the number of victims targeted. In the Natanga case, the trial chamber noted that the assessment of whether the attack is widespread is neither exclusively quantitative nor geographical, but must be carried out on the basis of all relevant facts in the case. In the sense, Your Honors, an attack in a small geographical area but directed against a large number of civilians is considered sufficient for widespreadness, according to the ICTI's Cordit case in its paragraph 1940 of the appeals judgment. In the case at hand, the submission of the expressive number of at least 30,000 Earthbauers to forced labor amounting to enslavement readily illustrates the high number of victims and therefore the widespreadness of the attack. Moreover, this case is not built in widespreadness alone, but we submit that the attack was also systematic. As the trial chamber in the Katanga case noted that an attack is considered systematic by its organized nature of the acts of violence and the improbability of their random occurrence. In this sense, the prosecution recalls that since 2015, in order to gain control over Black Mao province, Mr. Blaze for 4 consecutive years has openly targeted the Earthbauer population and their culture, as we may assess in paragraphs 4 to 6 of the case facts. Violent actions and repressions against the civilian population were consistently made throughout the years, such as the imprisonment of civilians and religious figures, regular house intrusions, and violent disbandment of peaceful gathering, as well as listing mere supporters of the separatist movements as terrorists. These actions, added to Lord Blaze's political motivation of controlling the Black Mao province, portrayed the manifest systematic nature of the attacks, as it was committed in an organized manner for consecutive years. Hence, we submit that the nature of the attack was sufficiently widespread and systematic. Secondly, the attack was also pursuant to a state policy. Your Honors, according to this court in the situation of Kenya, the requirement of a policy implies that an attack follows a regular pattern, and that if this attack is planned, directed, or organized, is enough to satisfy this criterion. Moreover, this court noted that in the confirmation of charges of the Gebargo case, that the use of public resources and political objectives does indicate that an attack would be pursuant to a state policy. And Your Honors, this is also clear in the facts, as Mr. Blaze's anti-extremism executive order tasks the Bureau of National Security to unrestricted use the means necessary to end potential threats to national security, and therefore actively promoted and encouraged the attack against the Earthbauers, providing for elements of the crimes of Article 7. Hence,
Counsel,
having met, yes, Your Honor?
if I may shortly, you referred us to Lord Blaze requiring all means necessary. So take that to mean illegal means as well. Or otherwise phrased, why aren't we to consider that, well, all reasonable steps or measures or whatever always means or supposed to mean within legal constraints?
Well, thank you, Your Honor, for your honest question. To answer your question, the prosecution submits that the fact that the Lord Blaze signed an anti-extremism order is very vague ordering when it comes to the necessary means, with any restriction or definition of what this national threat would constitute or who would constitute this national threat. It is reasonable to comply with the element that it is reasonable to infer that it would be also considered illegal and even extreme measures, as it did not comply with any limitations to what necessary means would imply in this case. That is why we, having met the specific and contextual elements, we submit that this court has subject matter jurisdiction within the present case. And the honors, moving forward to the second issue of admissibility, this case may be deemed admissible once this court is satisfied on its own jurisdiction. Therefore, the burden hence rests on the defense who is challenging admissibility to prove otherwise. This was noted by this court in many cases, such as Prosecutor versus Bruto, Kenyatta, and Bemba. The honors, there is one possible ground which the defense may attempt to challenge admissibility. That is the allegation that the Amnesty Law number 14 would amount to a trial and therefore bar the prosecution of the crime of enslavement by this court, supposedly in the furtherance of the ne bis in idem principle. However, the prosecution sustains that this submission is groundless, as there has not been any trial in the state of Fire Republic for the ne bis in idem principle to be even considered to apply in the present case. Your honors, in the Gaddafi Appeals Chamber decision in its paragraph 7 and 8, it was established that a trial is considered to have taken place and thus the ne bis in idem principle to be applicable, where a previous final judgment in the sense of having res judicata effect in the national system have taken place. The res judicata effect, your honors, has two main limbs. First, not only it relates to a final decision in the sense of exhaustion of legal remedies, but also and foremost, it relates to the existence of effective investigation and prosecution that leads to a merit-based decision on acquittal or conviction of the accused, as established in the Gaddafi Appeals Chamber decision in the Nasser Orich IC2I's case. In the sense, for a judicial proceeding to be considered with res judicata effect, both requirements must necessarily be present in conjunction. In the present case, your honors, although clarification 6 places the judge's ruling as final, it is clear that the second requirement of a trial is not established, reason why this proceeding cannot possibly amount to a trial. There hasn't been any concrete investigative steps to prosecute Mr. Blaze, leading to either a merit-based conviction or acquittal. In fact, what took place was a mere confirmation of a general amnesty law by a judge only 1 month after the adoption of the amnesty and 4 days after Mr. Blaze's public apology. Henceforth, the prosecution submits that the national proceedings granting the amnesties, which has no res judicata effect, is inoperant to render the inadmissibility, and its consideration would be detrimental to legal security. As for the third count, regarding the interest of
Counsel, I have a question because I think that at some point the prosecution point of view is a very strict point of view in terms of what trial means. And we know that the situation in Fire Republic is very delicate. There's a situation where the society needs to go further and try to reconcile and try to move forward for a future, a best future. So in this particular case, complementarity cannot be interpreted in a way that, for example, through commissions and other kind of reparation measures can be taken for in this concept, and for example, the amnesty law.
Thank you for your honest question, Your Honor. The submission of the prosecution relies on the fact that even the amnesty laws could be legal or applicable to international courts, a general amnesty law would be incompatible with international law in this court's ruling. As in the difference in the other transitional measures acts, an amnesty law that is then general, that does not specify which persons are amnested, are granted for amnesty, and what crimes, and with the specific limitation that crimes, serious crimes such as crimes against humanity, should not be granted amnesty. This is the understanding of this court and also of other courts of international human rights courts, such as the Inter-American and the European Courts of Human Rights, for example. So if I may proceed to the interest of the justice, if I
may quickly.
Yes, Your Honor.
You referred us to international human rights jurisprudence. Are we bound by human rights jurisprudence, or in how far are we to take it into account?
Thank you, Your Honor. Certainly, this court is not bound by other court jurisdictions. However, considered Article 21, Paragraph 3, it says that this court should rely on international human rights laws, international human rights norms, and we say that the precedents of this court are persuasive for this court to consider. So if I answer your question, I would like to proceed with the third count that is regarding to the interest of justice. Article 53, 1C of the Rome Statute connects interest of justice to the interest of the victims in the case. In the decision on the initiation of an investigation in Afghanistan, the appeals chamber reversed its previous decision on lack of interest of justice and ruled in favor of opening an investigation, as at this stage, it is only requested reasonable factual basis for the prosecution to proceed, in the sense that a crime has been committed in the scope of this court jurisdiction. With this being said, the prosecution has already shown that the case against Mr. Blaze falls within the jurisdiction of this court and is admissible under Article 17. It is also clear the interest of the victims, the thousands of earth bowers submitting to enslavement and their families in seeing justice done. Furthermore, Article 31 of the Vienna Convention on the Law of Treaties, we shall resort to the preamble for interpreting the purposes of a convention. And the Rome Statutes affirms that the most serious crimes of international community concern must not go unpunished, and ensuring an effective prosecution. The present crime of enslavement readily urges the exercise of the objectives and purposes of the Rome Statute. On a different note, it should also be within the interest of this court to have the opportunity to analyze and try a crime that has only two precedents in this court, and only in regard to sexual kind of enslavement, that is the Katanga and the Natanga case, in order to save the interest of justice of the international community as a whole, and ensuring that the individual responsible for the present crime, Mr. Blaze, do not go unpunished. Therefore, we submit that the case against Rod Blaze would serve the interest of justice. For the fourth and last count, we submit that there are reasonable grounds for believing that Mr. Blaze is responsible for the crime against humanity of enslavement, under the mode of liability of superior responsibility of Article 28b. For the court to hold a superior responsible for crimes committed by subordinate, four elements must be present. They are the relationship of subordination with effective control, knowledge of the crime, failure to prevent or punish the subordinate, and specifically the ICC statute requires that the commission of the crime is a result from the failure to exercise control. The prosecution will demonstrate that Mr. Blaze is responsible for the crime committed within these four elements. First, Mr. Blaze had a superior subordinate relationship with effective control over the perpetrators. The ICTY's Hadovan case defines superior as someone who possesses the power or authority in either de jure or de facto form over its subordinates. The court noted that this effective control consists in the power to prevent, punish, or initiate measures leading to proceedings against the alleged perpetrators. And the assessment of this control includes, inter alia, the superior capacity to issue orders, the authority to issue disciplinary measures, and the power to promote and terminate positions held of personnel. In the case at hand, Your Honors, as the President of Fire Republic, Mr. Blaze have a de facto and a de jure position of the Vienna's agents, including Mrs. Ursa Azila, who are subordinates tasked by him to end the said potential national threats, who acted at the Center under his instructions, according to paragraph 7a in the anti-extremism order. Moreover, exhibits 1 and 2 in the records infers that he was the person in charge of the Center, giving direct orders to Mrs. Azila on the administration of resources, personnel, and allocation of detainees. Secondly, we submit that there are reasonable grounds to believe that Mr. Blaze knew.
Sorry, Consul. There's a bit of delay, sorry that I interrupted you. In relation to the first point that you are arguing, the subordination, there's something important that we should consider in terms of that we are talking here not in the aspect of the military superior. And you are bringing jurisprudence from the ICTY, which didn't include similar situation as the ICC. So in this particular, what this court should have into consideration, because of course, as in a bureaucracy, it's not possible to control every single step that happens into a specific line. So what would be the difference between this standard that you are depicting, which is for me similar or is the same for military superiors? Thanks.
Thank you for your question, Your Honor. The prosecution submits that it's true that this court has not yet decided on superior responsibility, but only command responsibility. However, considering that this is the Bemba case, it is the only precedent of this court talking about that concerns the ruling of commander responsibility, it is still relevant and pursuant to this case if it is applicable mutatis mutandis, considering the thresholds of the Article 28b. There are, for example, the authority not on a specific order, but simply an effective control over the subordinates. So we submit also that there are reasonable grounds to believe that Mr. Blaze knew or consciously disregarded information. And this is also considering that this court has not decided on superior responsibility in itself, that the IC2I and IC2R law, such as the Radovan and the Himana cases, are relevant to the case at hand. These courts took notice that the had reason to know standard would be enough to provide for the mens rea for superior responsibility. And this standard is met when the accused had general access to information which would put him on notice of possible unlawful acts by his subordinates. Nonetheless, the case at hand also fulfills the highest threshold of the Rome Statute, that is of knowledge and consciously disregarded. As considering the facts in the case, Your Honors, mainly the content of paragraphs 4 to 6 in Exhibit 1, it is reasonable to believe that the anti-extremism executive order is part of a broader policy, in which Mr. Blaze intended to take control of the Black Mountain province to the detriment of the Earth Power minority and by any means. By signing an anti-executive order and tasking the BNS to use the necessary means to end the potential threats to national security, a very vague and broad instruction, as mentioned before, with no criteria to what this potential threat to national security would constitute, is reasonable to infer that Mr. Blaze knew that crimes would be committed as a consequence of such unrestricted order. Alternatively, we submit that Mr. Blaze will need to consciously disregard information in order to be unaware of the crime committed by his subordinates. As Mr. Blaze had easy access to information on the Centurig as a president and was up to date on the numerical situation of the detainees on the resources needed, according to Exhibits 1 and 2. Also, Mrs. Azila had sent at least 2 official reports in the time being of the conversation of Exhibit 1. Also, Exhibit 1 demonstrates the close contact between Mr. Blaze and Mrs. Ursa Azila, which is reasonable to infer that the implementation of his unrestricted order in the normal course of events would lead to the commission of crimes and his knowledge on it. In this sense, we also submit that Lord Blaze failed to take all the necessary and reasonable measures to prevent or repress the crime. Considering this court's precedents in the Bemba appeal judgment, this court established that the standard for this element is connected to the commander's material ability to prevent or repress the crimes. And Mr. Blaze could have foreseen the likelihood of the commission of the crime when he tasked the BNS to use the necessary means. As the president of the Fire Republic, he had the whole state apparatus at his disposal. Yet, from the opening of the detention center until the peace agreement, 10 months had passed, and Mr. Blaze did not take any measures to even assess the situation in Centurig, even less to prevent or repress the crime committed. Even less also to submit the matter to the competent authorities for investigations, for example, as it was expected. Lastly, we submit that the commission of the crime was a result of Lord Blaze's failure to exercise control. Also in the Bemba case, the trial chamber understood that it is only necessary to prove that the commander's omissions increased the risk of commission of the crime. Following this court's understanding, the risk of commission of enslavement in Centurig was increased as Lord Blaze gave vague and unrestricted orders to the BNS to end any potential threat in targeting the Earth Power minority.
Counsel, I have a clarification in this point because you were quoting Exhibit 1 and 2, and from Exhibit 1, it seems that the Lord Blaze raise a point of how many detainees were sent to that specific center. So he was trying to put a limit on the situation and, for example, try to deal with something that can happen. That is why he decided to move some people. So why you are assuming that with this he's not taking measures to reduce, for example, in a specific act?
Thank you, Anna. We say that Exhibit 1 actually is a very piece of information that also we can infer other informations from it. We understand that it's not enough to suffice for the necessary measures that are required for the Rome Statute, and also that he himself has knowledge of the situation. However, he gives direct orders when it comes to the numerical situation. This is not necessary measures to prevent any crime whatsoever. Also, we like to point out that the fact that he mentioned the mutinity in this aspect also considers and confirms the fact that this is probably not an educational center, and this is why also it is within his duty as a superior to understand what was happening, assessing the situation, and controlling the situation if it was in his power. And in conclusion, in order to control the situation, Mr. Blaze should and could have informed suspicions of a crime against humanity committed. However, he didn't act in accordance with his obligations as superior. Consequently, his failure to exercise control resulted in the increase of enslavement committed. To finalize, Your Honors, at least 30,000 Earth Bowers have been unlawfully detained, submitted to forced labor under the menace of penalties and punishment. And in the meantime, the State of Fire Republic has failed to investigate and punish the responsible for this mass atrocity, shielding Mr. Blaze, who continues to deny involvement. Therefore,
Counsel,
on the basis of the evidence...
I'm afraid I have to interrupt you.
Yes.
I know we've been bothering you with questions, but your time's up because of it.
Certainly.
We won't hold it against you.
Thank you.
Thank you very much. And then the defense has the floor.
Good afternoon again. Mr. President, Your Honors, may it please the court. Your Honors, I am standing here today on behalf of Lord Blaze, a man who has been portrayed by the prosecution as a merciless criminal, capable of committing unspeakable crimes against the Earthbower population. On the contrary, a man that, as the defense will show through this hearing today, has always interpreted his official role as president with the sole purpose of ensuring peace and security in both Fire Republic and Black Mound. I will prove, firstly, that the case against Mr. Blaze does not fall within the jurisdiction of this court. And secondly, that the case at hand is inadmissible before this court pursuant to Article 17(1)(c) of the Rome Statute. Subsequently, my co-counsel will additionally prove that Mr. Blaze is not criminally responsible for the alleged crimes under Article 28b of the Rome Statute, and that the case at hand would not serve the interests of justice. With regard to the first submission, the defense challenges that the case falls under the jurisdiction of this court, in particular, having regard to the jurisdiction ratione materie pursuant to Article 5 of the Rome Statute. Your Honors, the defense will prove that both the contextual element and the specific objective elements of the crime of enslavement are not fulfilled. And as regards the contextual element, we will only focus on the civilian population requirement and the policy element due to time limits. As far as the civilian requirement is concerned, the defense submits that the adduced evidence fails to prove that the alleged attack was primarily directed against the Earthbower civilian population. Indeed, as stated by the pretrial Chamber 2 in the ICC Bemba decision on the confirmation of the charges at paragraph 76, the civilian population ought to be the primary object of the attack. However, in the case at hand, civilians may have been regrettably targeted, but only incidentally. Your Honors, by looking at paragraph 7 of the case facts, it is undeniable that targets of the Executive Act were members of organized resistance movements, which, as such, are not entitled to the protection accorded to civilians in international humanitarian law, as clearly stated in Articles 43 and 50 of the Additional Protocol 1 to the Geneva Conventions. As far as the policy element is concerned, the defense maintains that, according to Article 7.2a of the Rome Statute, such policy must have been directed to commit an attack against civilians. Mr. Blaise's instructions, on the contrary, were issued for the sole reason, and I quote, to re-establish peace in Black Mound, and therefore are to be considered merely political in nature. Your Honors, as clearly affirmed by pre-trial Chamber 2 in the ICC Ruto decision on the confirmation of the charges at paragraph 213, the presence of a merely political policy alone is insufficient to qualify the alleged policy under the legal framework of crimes against humanity. Indeed, to meet the policy requirement, there are several crucial indicia that ought to be taken into consideration, such as recruitment, map preparation, target identification, weapon supply and logistics, the presence of preparatory meetings at which the alleged policy was allegedly adopted. Your Honors, in the present case, there are no reasonable grounds to believe that this kind of policy was promulgated, as there is no evidence of Mr. Blaise's involvement in the practical planning of the alleged policy, having he merely requested the Minister of Interior to monitor the situation and use the necessary means to end potential threats to national security.
Counsel.
Yes.
Would it be necessary for us to find, in order for us to find, a policy having existed, that Lord Blaise was involved in that policy, or could a policy be established without Lord Blaise being active part of it?
Thank you for the question, Your Honor. The defense is well aware that, as established in the Ruto decision, the implementation of a policy can also consist in a deliberate failure to take action, which is consciously aimed at encouraging such attack on the side of President Blaise, of course, in this case, but still, we still would have to establish in the present case the objective indicia, some objective indicia that indicated the presence of a policy. And in the case at hand, the defense is of the view that we do not have any objective indicia indicating such thing. Thank you, Your Honor. We now move on to the specific objective elements of the crime of enslavement.
Can I interrupt? Sorry,
yes.
To ask for some clarification. It's going back to your points on the attack against the civilian population. Can I just ask the defense to clarify a little bit your position on some of the evidence about discriminatory measures that were brought in, and how that was not against the civilian population, if possible, please?
Yes, Your Honor, thank you for the question. The defense is of the view that, again, civilians, unfortunately, may have been regrettably targeted by the attack, the alleged attack, but only incidentally, as the attack was clearly pointed to the ANG leaders for the peace and the security of the country. And again, we know that in these cases, civilians may come in the way, in the fire, we might say, but still this does not amount to an attack against the civilian population for the requirement of crimes against humanity. Thank you, Your Honor, I may proceed. Moving back to the specific objective elements of the crime of enslavement, the defense indeed recognizes that forced labor can constitute enslavement, as clearly stated in the elements of the crimes at footnote 11. However, not all labor performed by civilians deprived of their liberty is prohibited, as they can be made to work under certain circumstances. Such prohibition only applies against forced or involuntary labor. Your Honors, the Counsel of the Defense submits that labor performed by the Earthbowers detainees was neither forced nor involuntary. Indeed, what characterizes forced labor according to the trial chamber in ICTY Karnielac's judgment at paragraph 359 and 370 is, first, that the persons had no real choice as to whether they would work, and second, that the detainees were kept imprisoned for the primary purpose of being used for forced labor. With respect to the first point, it is undeniable that a choice was given to the detainees as to whether they would join the educational program and therefore work in the centers and have their sentence reduced, as clearly emerges from paragraph 9 of the case facts. With respect to the second requirement, the defense admits that the primary reason for the Earthbauer's incarceration was not to perform forced labor, but to serve a sentence while being able to rehabilitate themselves through the aforementioned program. Moreover, claims of forced labor in the case at hand only rest on Haru Rock's interview. Your Honors, the defense admits that such interview is not a reliable source by any standard of this court. Not only there was no explanation whatsoever regarding its methods, but also the interview itself lacks any objective foundation. Indeed, as noted by the appeals chamber in ICTY Carnielach appeal judgment at paragraph 195, the detainees' personal conviction that they were forced to work must be proven with objective and not just subjective evidence. Your Honors, in the case at hand, there are no objective evidence suggesting that the specific circumstances in the detention centers were such as to make free consent impossible. Therefore, given the fact that the conclusion that labor was forced cannot be presumed solely from Haru Rock's interview, the defense once again reiterates that the actus reus of the crime of enslavement is not fulfilled in the case at hand. If Your Honors allow me, I will now move to my second submission.
If I may, counsel, in relation to this point of the evidence, you are mentioning that we should have into consideration other kind of evidence, like in addition to the statement that you are mentioning. But I mean, in this court, in the rules of procedure and evidence, we have that there's not a rule for asking for corroboration evidence. So I mean, for this preliminary moment of the investigation, this is not enough to move forward.
Well, Your Honor, thank you for the question. First of all, the defense is of the view that, firstly, the Haru Rock interview relies, well, it's contained in an NGO report, that contained no explanation, as I said, on the methods and on the condition on the interviews and duration of the interviews. Moreover, Your Honors, we would like to remind the court that this NGO report was published only in 2020. So a long time passed after the end of the conflict. Therefore, how would we rely on that for the point of evidence, from the evidentiary point, for the point of Mr. Blaze's acknowledgement about the alleged enslavement of the Earthbauer's civilian population. Thank you. Your Honors, the Defense Counsel challenges now the admissibility of this case on two grounds. First, the defense admits that the amnesty granted to Mr. Blaze under law number 14 does not violate international law and can be invoked before this court. Subsequently, the defense admits that the amnesty granted to President Blaze also qualifies under Article 17(1)(c) of the Rome Statute on the ground that he sought and obtained the amnesty protection provided under law number 14 on national reconciliation. With regard to the first submission, the defense wishes to recall Article 31 of the Vienna Convention on the Laws of Treaties, according to which treaties ought to be interpreted in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Accordingly, the defense does recognize that in the spirit of its preamble, the purpose of the statute is to put an end to impunity for the most serious crimes of concern to the international community as a whole. Nonetheless, the principle of complementarity, which is also mentioned in the preamble and further reaffirmed in Article 1 of the Rome Statute, is equally crucial for the functioning of this court. On that account, in the present case, nothing shall prevent this court to forego prosecution by virtue of the amnesty granted to the defendant, being the amnesty at stake, not a blanket one, but a conditional one. All the more bearing in mind that no treaty so far imposes on states a duty to prosecute crimes against humanity, while there is a consistent body of state practice which admits amnesties for such crimes. As regards the second submission, The Defense Counsel once again reiterates that the amnesty granted to the defendant does meet the legal standard required under Article 17(1)(c) of the Rome Statute for a declaration of inadmissibility. Firstly, the defense admits that by not specifying what type of trial is required for a declaration of inadmissibility, the Rome Statute allows the state to address crimes through any form of proceedings, not necessarily criminal ones. Furthermore, it is relevant to emphasize that the combined reading of Article 20 and Article 53 leads to the conclusion that a judicial proceeding, whether national or international, is not strictly required under the ICC statute for declaration of inadmissibility, while other instruments may suffice. Your Honors, the Defense Counsel maintains that Mr. Blaze's appearance and confession before the Truth and Reconciliation Commission, followed by the amnesty granted to him, ought to be considered the functional equivalent of having been tried and convicted. The defense also submits that the amnesty granted to Mr. Blaze undeniably concerned the same conduct as the present case, given the fact that the defendant's summon to appear issued by pretrial chamber 2 was related to the same crimes as the public apology provided by the defendant in order to obtain the amnesty itself. But most importantly, the defense admits that the amnesty granted to Mr. Blaze did not shield him from criminal responsibility, nor was inconsistent with an intent to bring him to justice. Your Honors, the amnesty at stake did not shield the defendant from criminal responsibility. Indeed, it is undeniable that the word shielding calls for a rather subjective interpretation, in the sense that what should emerge is a direct intent to deceive the rules of criminal trials for the purpose of impunity to the advantage of the accused. On the contrary, Amnesty Law number 14 did not distinctively privilege Mr. Blaze alone, but was aimed to extend from criminal responsibility all the actors involved in a conflict in order to reestablish peace, as paragraph 19 of the case facts clearly demonstrates. The defense also submits that the amnesty granted to Mr. Blaze was not inconsistent with an intent to bring him to justice, as this exception encompasses cases where the denial of an amnesty would not result in further criminal prosecution. On the contrary, being the amnesty at issue a conditional one, it required specific actions on the side of President Blaze, with the consequence that had Mr. Blaze failed to comply with any of the requirements, he would have faced prosecution before a national court, as clarified in paragraph 20 of the case facts. In conclusion, Your Honors, the Defense Counsel once again reiterates that the proceeding leading to the amnesty granted to Mr. Blaze was genuine, as it undeniably qualifies under Article 17(1)(c) of the Rome Statute. And it is indeed the genuineness of the proceeding that ensures that the perpetrator was in fact brought to justice and calls for a declaration of inadmissibility. If Your Honors allow me, I will now leave the floor to my colleague, Mr. Bastianini, for our last submissions.
Good afternoon, Mr. President, Your Honors, and may it please the Court. The Defense Counsel would now like to elaborate on our third and fourth submissions. Firstly, I will prove that Mr. Blaze is not criminally responsible for the crime against humanity of enslavement under Article 28b of the Rome Statute. Secondly, I will argue that the case against Mr. Blaze would not serve the interests of justice under Article 53 of the Rome Statute. The Defense Counsel submits that Mr. Blaze is not criminally responsible under Article 28b of the Rome Statute on the grounds that, first, Mr. Blaze did not have a de facto position of authority over the Minister of Interior and the Vienna forces. Second, the defendant did not fail to exercise control properly over Minister Azila. Lastly, Mr. Blaze did not know nor consciously disregarded information clearly indicating that the crime of enslavement was being committed. Regarding the first submission, the defense acknowledges that Mr. Blaze was Ursa Azila's de jure superior. Nonetheless, as the ICTY appeals chamber stated at paragraph 197 in the Celebici appeal judgment, the possession of the jure powers alone is not sufficient to ascertain superior responsibility if they do not amount to effective control. Particularly, the effective control required to establish superior civilian responsibility needs to be similar to the degree of control required for military commanders, which is, according to Trial Chamber 3 in the ICCC Bemba trial judgment at paragraph 183, the material ability to prevent or repress the commission of the crimes. When assessing effective control, there are several indicia that ought to be taken into consideration, among which the accused's ability to issue orders and whether those orders are in fact followed, the authority to apply disciplinary measures and to promote, demote, or remove particular soldiers, as stated by the ICTY trial chamber in the Parisi judgment at paragraph 148. Your Honors, while it is not contentious that the defendant had the ability to issue orders, the prosecution has failed to prove that such orders were in fact followed by the BNS, or that President Blaise possessed any of the aforementioned powers with respect to the BNS. Indeed, such powers were delegated by the defendant to the Minister of Interior, as clearly stated in paragraph 7 of the case facts. Your Honors, Mr. Blaise selected a high-ranking government official, instructed her to monitor the situation in Black Mount, and requested her to report on their activities, enacting an effective reporting system. Thus, there are no reasonable grounds to believe that an effective control test would be satisfied in the present case. Should Your Honors nonetheless find that Mr. Blaise had effective control over Minister of Interior Ursa Zila,
Counsel,
it would...
if I may, Exhibit 1 shows us that Lord Blaise was able to have a direct impact on what Ms. Ozila did, or also did, excuse me. So how do you reconcile that fact with your proposition?
Thank you for your question, Your Honor. The defense wishes to stress that in civilian settings, the relationship in hierarchical relationships are strikingly different. Indeed, in civilian settings, first of all, the ability to obtain information is less important than in military context. And also the power, like disciplinary powers or powers of sanctions attached in civilian leadership are less present than in the military settings. For this reason, the effective control required for civilian leaders would be different from the military ones, in the sense that the power, disciplinary power, would be different in those cases. If I may continue, Your Honor.
Yes, please.
Should Your Honors find that Mr. Blaise had effective control over Minister of the Interior, it would still, of course, need to be ascertained that the principal crime undertaken by the subordinate consists in the superior's failure to exercise control properly. It is the defense's admission that he did not. It is the defense's admission that Lord Blaise did not fail to exercise control properly. Now, moving on finally again to the mental element of superior responsibility. The defense disputes that in this case, the mens rea is satisfied, as both the requirement of actual knowledge and conscious disregard of information outlined by Article 28b of the Rome Statute are absent. As far as actual knowledge is concerned, there are no reasonable grounds to believe that Mr. Blaise knew that the alleged crimes were being committed, as his knowledge was limited to the contents of the reports issued by the Minister of Interior. As regards the conscious disregard of information, there are no reasonable grounds to believe that Mr. Blaise consciously declined to act upon information clearly indicating a significant risk that subordinates were committing a crime. Indeed, the information ought to be sufficiently alarming in the sense that it should justify a further inquiry by the superior to determine whether offenses are committed by the subordinate, as clearly stated by the appeals chamber in the ICTY Strugar appeal judgment at paragraph 304. Your Honors, in the case at hand, there are no reasonable grounds to believe that the defendant had the required standard of information. Indeed, Exhibit 1 and 2 do not show anything else beyond simple awareness that terrorists were indeed being detained and successfully re-educated in compliance with his own executive order. Finally, the defense wishes to stress the conceptual difference between liability for ordering pursuant to Article 25b of the Rome Statute and superior responsibility, which is an act of omission. It would be by all means against the purposes of this court to use the latter as fallback liability for cases in which a positive act within the framework of an hierarchical relationship could not be established. In light of the arguments presented, the defense counsel reiterates that Mr. Blaise cannot be held criminally responsible under Article 28b of the Rome Statute. If Your Honors will allow me, I will now move to my last submission. The Defense Counsel submits that the case against Mr. Blaze would not serve the interest of justice. Indeed, the word justice should not be interpreted in a restrictive sense by considering only those instruments that comply with retributive criminal justice. Indeed, retributive aims are precisely what a decision in the interest of justice countervails. As a matter of fact, Article 53 of the Rome Statute itself contemplates the possibility for the prosecutor to take into account broader concepts of justice that include, but are not limited to, the gravity of the crime, the interest of victims, the age or infirmity of the relevant person, and his or her role in the commission of the alleged crimes. And even if we were to limit the concept of interest of justice strictly to criminal justice instruments, the latter pursue multiple functions aside from retribution, such as deterrent, reformation, rehabilitation, and prevention. It is especially in light of the function of prevention that the defense strongly asserts that a proceeding before this court against Mr. Blaze will have a very detrimental impact on the stability of the region. Your Honors, the amnesty created the conditions for a lasting peace and reunited a country that had been torn apart by an internal conflict. At the same time, the acknowledgement of the truth reached by the Truth and Reconciliation Commission not only pursued the interest of the victims by facilitating public awareness and widespread catharsis, but also helped the alleged perpetrators to begin an essential process of reintegration into a new and peaceful society. Your Honors, given that both parties decided to put an end to the conflict through a peace agreement based on amnesties, to persevere with a prosecution imposed by this court would mean to jeopardize the very conditions for peace, destabilizing the delicate situation in Black Mount, thus certainly not serving the interest of justice. Your Honors, by reason of all the aforementioned arguments, the defense respectfully requests the court to declare that the case against Mr. Blaze falls outside the jurisdiction of this court pursuant to Article 19 of the Rome Statute, as both the contextual elements of crimes against humanity and the specific objective elements of the crime of enslavement are absent in the present case, that the case at hand is inadmissible under Article 17(1)(c) of the Rome Statute, that Mr. Blaze is not criminally responsible for crimes against humanity of enslavement under Article 28b of the Rome Statute, and finally, that the case at hand would not serve the interest of justice under Article 53 of the Rome Statute. Thank you, Your Honors. The defense rests.
Thank you, Counsel. Right on time. I think now it's the prosecution's turn again for the rebuttal.
Your Honors, may it please the court. The defense has made light of humanitarian rights issues, but the prosecution says that no crime against humanity must go unpunished, be in terms of peace or in armed conflicts. The prosecution will raise 2 points for rebuttal to show why the defense challenge must fail. First, that the attack was indeed directed against the civilians and rules of conduct of hostilities should not be applied. Second, that a trial has not taken place in the amnesty law number 14, being compatible with international law. On our first submission for rebuttal, the defense argued that the targeted subject were not of a civilian nature. However, they failed to inform and tackle the fact that a group would only lose its civilian status if they were members of an armed group with continuous combat function. And Your Honors, according to the ICRC guidance on direct participations in hostilities, this continuous combat function assumption must be made out on an individual basis analysis, asserting whether each individual could be regarded as having a specific continuous combat function within the group. In this manner, it is highly unlikely, not to say impossible, that the defense cannot establish to all of the 30,000 people submitted to enslavement were effectively members of armed groups and had continuous combat function. Moreover, protections in IX, which seems to be the case, it is not based on status, prisoner of war and protection of civilians status, for example, but on actual conduct. Reason why various decisions of the human rights bodies consider that the members of armed groups may be targeted as long as they do not fall into the power of the enemy or are otherwise ours to combat. Bearing this in mind, the defense attention in reaching to an analogy between the treatment of members of an armed group and prisoners of war, for example, of the Convention 3, is incapable of prevailing, as it is not sustained in neither treaty nor case law. And rules protecting persons in the power of the enemy are different from the rules of conduct of hostilities. On our second submission, the defense sustains that other restorative justice methods are valid to render a case inadmissible, and the prosecution does not deny it. However, in the concrete case, we sustain that such measures are not established. Firstly, because it did not consider the rights of reparations of the victims, as it is a general amnesty law that did not limit its scope and extend to serious crimes of international character, which is considered to be incompatible with international law by this court in the Gaddafi case, as well as other humanitarian human rights courts. Secondly, because it did not reach the threshold required for it to be considered as a trial. The grounds of inadmissibility is the nebis in idem, not complementarity, which demands a final decision with res judicata effect and a completed trial, not a mere apology confirmed by a judge. The prosecution emphasizes and submits that for a judicial proceeding to be considered with res judicata effect and the principle nebis in idem to be applicable, those two elements of a trial must be necessarily present, that is, investigation and prosecution with a merit-based final decision, not merely an apparent exhaustion of legal remedies. The defense sustained that the other in the second scope, we also submit that this incompatibility of general amnesty laws within the international law is noted not only by this court, but it's considered that amnesty laws for crimes against humanity conflict and are incompatible with states' positive obligations to investigate, prosecute, and punish, as it denies victims of such crimes the right to truth, access to justice, and to request reparations where appropriate. This is also provided by the transnational justice law, considering the UN Commission's rights, set of principles for the protection and promotion of human rights, which limits these amnesties to crimes that are not of serious crimes, even establishing that crimes against humanity would not be susceptible to grant of amnesties. Your Honors, considering the amnesty law, it is a general, amnesty law 14 is a general amnesty law, which does not exclude any category of the perpetrators of international crimes. If applied, would fall within the provisions of Article 17(2)(a) and exception of paragraph 3(a), as it would serve the purpose of shielding law-ablaze from the criminal responsibility. Therefore, in order to prosecute the responsible person, we urge this court to confirm the submissions made. And if there is nothing else I can be of assistance, I conclude the submissions made to the court. Thank you.
Thank you, counsel. And now for the defense again.
Good afternoon again, Mr. President, Your Honors, may it please the court. The defense will raise 3 points in rebuttal to the submissions of the prosecution. Prosecution has argued that the victim's interest would be unequivocally denied if the court were to accept the validity of the amnesty granted to the accused. Although prosecution has failed to prove the basis of its submission, we surely cannot just infer or presume that the granting of an amnesty would frustrate the interests of victims. For instance, with regard to the Georgia situation, and in particular in the decision on the prosecutor's request for authorization of an investigation at paragraph 58, victims indicated their overwhelming preference for the opening of an investigation. In South Africa, on the contrary, many praised the amnesty approach based on the African notion of Ubuntu, which explicitly excludes retribution and favors restorative justice. The defense therefore reiterates that no evidence were adduced by the prosecution as to whether amnesty law number 14 will frustrate the interests of the victim, and that such frustration cannot surely be inferred from the circumstances of the case at hand. Moreover, prosecution has argued that it exists a customary international rule that prohibits amnesties for crimes against humanity, for serious crimes, serious international crimes. Your Honors, customary international law exists if actual practice, the so-called repetitio facti, can be found based on a sense of legal obligation, the opinio juris sive necessitatis, we certainly cannot state, as today, that there is a general and consistent practice followed by state to investigate and prosecute crimes against humanity. And therefore, we cannot claim that there is a general customary law providing for a duty to prosecute such crimes. And this is because state practice is very inconsistent, and some states are still granting amnesties for serious crimes. And with regard to the Gaddafi situation, while confirming the decision of a pretrial chamber, the case was deemed admissible, the appeals chamber retracted from the findings of the pretrial chamber regarding the question of the compatibility of Law 6/2015 with international law by determining that they were obiter dicta. It was held that the pretrial chamber statement about a strong, growing, universal tendency opposing the grant of an amnesty for crimes against humanity needed to be interpreted as a mere acknowledgement that the question of the permissibility of amnesties was not settled yet. And therefore, for the purpose of admissibility challenge, the appeals chamber decided that it was sufficient to say that international law is still in the development stage on the question of acceptability of amnesties. With regard to the third point, prosecution claimed that Mr. Blaze failed to take necessary and reasonable measures to repress the commission of the crimes. Your Honors, this statement could not be further from the truth. Indeed, as stated by pre-trial chamber 2 in the ICC Bemba decision on the confirmation of the charges at paragraph 439, the duty to repress concerns both a duty to stop ongoing crimes and a duty to punish those responsible after their commission, which is alternative to the duty to refer the matter to the competent authorities. In the present case, Mr. Blaze fulfilled both duties. Firstly, undertaking necessary measures to stop the commission of the crimes by ordering the BNS to start peace negotiation as stated in the case facts at paragraph 17. Secondly, with the institution of a Truth and Reconciliation Commission, thus also fulfilling the duty to punish with the commitment to verify the establishment of the facts. In conclusion, Your Honors, the defense would like to emphasize that the use of criminal law, not only at the domestic level, but also at the international level, is only admissible as a last resort. That is, when all other protective mechanisms fail, whether nationally or internationally. And this is because this court is a complementary court. Your Honors, in the case at hand, we are looking at a perfectly functioning protective mechanism, a Truth and Reconciliation Commission paired with not blanket, not personal, but conditional amnesties. We are looking at a mechanism that represents the last piece of the puzzle in a difficult 2-month-long peace negotiation that was initiated and supported all along by President Blaze himself. And honoring such peace negotiation by complying with the amnesties granted alongside would demonstrate the court's spirit of complementarity and its cooperation with the existing cultural processes. This concludes my submissions, unless I can be of any further assistance to the court.
Thank you, counsel. Are there any questions from the bench? Okay, then we shall now retire to deliberate.
I will now send the judges into the deliberation room and put the team members into separate breakout sessions. The judges will be here in a minute.
So is everybody back? Good. Before I shall announce the winning team, I would first like to give my colleagues the possibility to provide you with some feedback. But before we do that, thank you to you all. It was quite impressive. And as you may have figured from the time it took us, it was really hard to decide. But now for feedback.
Okay, I want to just firstly say well done to everyone. It was very enjoyable and yeah, well done. A few bits of feedback that I wanted to give. Firstly, just on structure, I thought that it was really good when you were speaking, you went through the law and then you went through the factual analysis, and you were very clear on what your factual analysis was. So that was great, and keep that up because it made it a lot easier to follow. I would say sometimes I think, and this sort of goes across the board, that having indicators of where you've been and where you're going at each stage, it takes a little bit of time, but I personally find it easier to follow. So this is what I've covered and this is where I'm going next, just at each point, just so we know how your speech is structured. I think also for all of you just to slow down a little bit, and that will also make it easier to follow. And then kind of my last point really is to make sure that when you are going through each section, particularly when you're going through the jurisdiction section and also the superior responsibility section, to make sure that and this particularly for the prosecution, just because it's obviously the prosecution who has to prove these points, but to go through each element one by one and not to skip any of the elements and go through that. And it's a good way to make sure that you hit everything that the judge needs to know, and also to anticipate where the defense will go with that as well, and have it all up front and have your arguments really clearly set out. But I think that in general, it was really good. So well done to everyone.
Well, thanks, Ruby, and I join her in the words. I think that you did it really well, and also, of course, knowing that with the technological distance, it's more difficult to get convinced. So you did it both. So it was also difficult in that sense for us the decision. I will add some extra comments to what Ruby mentioned. For both teams, it's important to know that we see if you are reading or not. We identify, because for us the reception is different, and you see that you are like looking at the camera or not. So try to of course you follow a structure. It's not that you don't have to have things written, but try not to skip that time on the things that you have in the computer. Try to make visual connections with the judges. Try to be more emphatic in some points. So just to put things more like in a natural way. The other thing is, the issue of the structure was really good for both teams. I would say that there's more. You didn't mention the latest jurisprudence and issues, so I would recommend you to start like digging in more with some topics in relation to the defense. For example, I would try to foresee some arguments that are typical for the defense, like procedural issues. Be prepared for those kind of things. because those are one of the main arguments that the defense would try to put when you have substantive arguments on the other side. So that would be more my points. And yeah, in terms of time management was really good. Also, of course, we made a lot of questions, and this is normal to have a bit of, to know the reaction, also to know what is the law that you know and the facts. So you acted very well. So sorry if we bother you a bit, but it's a bit our function a bit. So with this, I'm done, Nicolai.
All right, thank you. I can only say that I fully agree with my colleagues, especially regarding questions. And in terms of what was really impressive, we think, was the rebuttals you did. They're quite good. And apart, besides asking questions that how we can see how well you are prepared with arguments that may have not been raised before, you don't know them, you addressed them very well. That was very well done. And now for the part which is most interesting to you, we feel like that the prosecution has presented themselves a bit better, but it took us a really long time to come to a conclusion. But congratulations to both teams, prosecution especially. Of course, it was really worthy of the last 16 round. And with that, court is adjourned.
Thank you very much, Your Honors. And thank you to the defense team as well.